stabbing someone because you get pushed. It doesn't matter if you're black, white. The race of the victims were reversed, the size were reversed, man, woman. You can't stab someone because you get pushed. That's just, in my opinion, as a prosecutor, objectively unreasonable under any circumstances.
The race always matters. It is naive to think that a all-white and Asian juror has the same attachment and concern for a defendant who is black. Racial bias still exists in the system, even if you're complying with the law.
It's a murder case that sparked nationwide debate, divided public opinion, and ended with a jury taking less than 3 hours to reach a verdict. Less than 3 hours. That's all it took for a Texas jury to reject a self-defense claim, find 19-year-old Karmelo Anthony guilty of murder, and sentence him to 35 years behind bars. The case centers on the death of 17-year-old Austin Metcalf, who was fatally stabbed during a rain-delayed high school track meet in Frisco, Texas, after a dispute under a rival school's tent. What began as a brief confrontation between two teenagers who had never met quickly became one of the most talked-about criminal cases in America. Anthony has since filed an appeal, keeping the legal battle far from over. Anthony is black. Metcalf was white. Anthony was significantly smaller than Metcalf. Those facts fueled fierce debate over self-defense and race, not simply online, but also amongst the crowd that gathered outside of the courthouse. I'm Katie Forrester with the US Sun. Don't forget to like and subscribe for more exclusive interviews. Joining us to discuss the verdict are two attorneys with extensive criminal law experience. Former federal prosecutor and legal analyst Nima Rahmani believes the jury got it right, and veteran Texas defense attorney Sam Bassett argues Anthony acted out of genuine fear and that the sentence was too harsh. Let's get right into it.
My name is Nima Rahmani. I graduated from Harvard Law School at age 22, worked for the largest law firm in Los Angeles, then worked for the Department of Justice, where I primarily handled drug and human trafficking cases. Then I worked for the city of LA, doing public corruption and government ethics before starting my own firm, West Coast Trial Lawyers. We are headquartered in Los Angeles, where I'm sitting right now, but we have offices in Las Vegas, Phoenix, and Seattle. And now I primarily represent victims in civil plaintiffs' cases, so civil rights, personal injury, and employment.
Fantastic. And I know I won't have to ask you how long you've been following this case, because I know you like to know everything about all of them all at the same time. So what were your first impressions of this case, and were you surprised that he was actually charged with murder?
I wasn't surprised. Really, this case got a lot of attention because Karmelo Anthony was charged with murder, and then he was released on bond. And the case got a lot of attention because it involved two high school students. Any type of school violence does get attention. But there was significant racial unrest really in the beginning of the case. The victim, Austin Metcalf, was white, Karmelo Anthony being black. And of course, there were individuals who thought that he should have been detained pending trial. There are people that thought he should get the death penalty now. You can't execute a minor. And Anthony was a minor, 17 years old, when this murder happened. But the case got a lot of attention on traditional media, social media. People were upset at the judge. And ultimately, when it became clear that it was going to progress to trial and that Anthony was going to assert a self-defense defense, people started showing up outside the courthouse on both sides. Members of the Proud Boys, reportedly Black Panthers as well. So that just added fuel to the racial fire.
Yeah, this has really sparked nationwide debate, hasn't it? There's so many things, like you say, from self-defense laws, race, and even social media was involved. If this came across your desk, what would be your first course of action?
So having practiced on the West Coast and being a former prosecutor, I probably have a little less liberal view when it comes to self-defense. In certain cases, especially in the South and in Texas, the jurors and a lot of the folks there, they have a much broader view. In my mind, and maybe because I'm a lawyer and I understand the law and I've prosecuted these cases, you can only use deadly force if you're at imminent risk of death or serious bodily injury. And this same standard applies to anyone. We sue law enforcement for using deadly force in situations where it's not appropriate. I've prosecuted individuals who have raised self-defense arguments. So that's a high legal standard, imminent risk of death or serious bodily injury. And importantly, when it comes to any use of force, it has to be reasonable. And when it comes to deadly force, it has to be proportionate. So when I saw this case, I viewed it as a fist fight or really pushing and shoving, right? There were no punches thrown. So I asked myself, is bringing a knife to a fist fight, is that a reasonable and proportionate use of force? And I did not think so.
And did you have that opinion from the get-go, or was this something that once you'd actually read all of the details of the case?
Well, certainly a lot more information came out at trial.
Mhm.
Information like the size disparity, the fact that Metcalf had a twin, there were other people in the tent. Obviously, those facts matter, and my opinion became more entrenched as the trial progressed. I think one of the biggest developments to me was that Karmelo Anthony did not testify, and that was a huge factor. And let me tell you why in a couple of ways. First, the conventional wisdom is in a self-defense case, the defendant has to take the stand and tell his or her story. It's very hard to perfect self-defense without it. And the reason I talked about perfecting self-defense, there are actually two types of self-defense in states like Texas and in California where I'm sitting. There's perfect self-defense and there's imperfect self-defense. And it's important to know there's distinction between the two. Perfect self-defense is an absolute defense to the crime or a civil lawsuit. If you reasonably believe that you're at imminent risk of death or serious bodily injury, and by an objective standard, that means an objective person in that same situation, and your use of force is proportionate, then you get an acquittal. You cannot be convicted and you can't be sued civilly. But there's also an intermediate type of self-defense, and it's called imperfect self-defense. Imperfect self-defense says that if you genuinely, in your heart of hearts, subjectively believe that you're at that risk of death or serious bodily injury and it's imminent, but it's unreasonable, but it's genuine, that reduces murder to manslaughter. So in the case of Karmelo Anthony, that would have reduced his exposure from 5 years to life to 2 to 20 years. And I think the defense's best chance in this case would be to argue that Karmelo Anthony really thought that he was going to be jumped and seriously injured because there were so many people in that tent and the size disparity, but it was unreasonable. That would have gotten him down to manslaughter. I think that would have been probably the only chance he would have gotten to get away from that murder charge, to argue that it was an unreasonable type of self-defense. But ultimately, the defense tried to swing for the fences, go for a home run. They didn't put their client on the stand, and they failed.
Absolutely. And how do you think this would have played out differently if cameras were allowed in the courtroom? Because obviously that was a big topic throughout.
I'm a big believer in cameras in the courtroom. I believe in transparency in this country, and, I've handled cases, with cameras and without. And there is a strong presumption that trials in this country are open to the public, and I don't see a particularly good reason to deny the public access. There's a lot of misinformation out there. And certainly you don't want to point cameras at the jurors, for instance. They deserve their privacy. Already people don't want to serve as jurors. And in this particular case, the jurors were sequestered, which made it even more difficult. But certainly as far as the witnesses, to the extent they're not minors, the defendant, the judge, the lawyers, I do believe there should be cameras in the courtroom. And it will just help restore trust in our criminal justice system and dispel rumors and conspiracy theories and the like.
And the trial only lasted 5 days. I think the defense rested after 1. How would you have done things differently if you were on the other side?
I would have 100% put my client on the stand. First of all, I would have tried to negotiate some sort of manslaughter deal. Pushing a case like this, although at a trial, is very risky because, again, he shouldn't have had that knife at a school event or sporting event. That's just unlawful, even though Texas state law does allow you to have knives less than 5 inches long. It was 3.5 inches, I believe. The defense tried to argue that it was some sort of tool. I don't think that was a credible argument. And if I were defending this case and I didn't negotiate a deal, I would have put my client on the stand in order to have my client really tell their story. Now, typically, a criminal defendant has a Fifth Amendment privilege against self-incrimination. They don't have to take the stand. They have the right to remain silent. But again, self-defense cases are different. They're very hard to win without that. I think the defense thought one of two things: that their client would get torn up on cross-examination because of his age, and two, that some of the good statements actually came out during the prosecution's case that he admitted to stabbing Metcalf and said that he told Metcalf to put his hands on, to not put his hands on him. So really, Anthony set out that self-defense argument immediately. The problem is, being pushed with one arm or two doesn't really make much of a difference, even though that was discussed at trial. For me, doesn't give you a right to stab someone in the chest. It is unreasonable. It's disproportionate. I think the defense should have gone up there and talked about how Anthony was afraid. He was surrounded. He thought he was going to get jumped. He thought he was going to get beat up pretty badly. And he really did this because he did believe that he was going to be seriously injured. And even though it was unreasonable, it was genuine. And that's why they should return a verdict on manslaughter, or, which was somewhat similar and discussed at sentencing, sudden passion. The biggest mistake the defense made in this case is not putting Karmelo Anthony on the stand. They needed him to testify that he thought that he was in imminent danger. He was going to get jumped. Metcalf and his twin brother were a lot bigger than him. He was outnumbered. And even though it was unreasonable to stab someone under the circumstances, he did genuinely believe that he was at risk of getting seriously injured. I think that's really the only viable path in the case. I would have tried to negotiate a manslaughter deal. If I were the defense, I would have asked the jury to return a not guilty on murder, but a guilty on manslaughter. And during the sentencing, they tried to do some of this. There's a sudden passion defense. Texas is unique in that the defense can actually ask the jurors to return a sentence and not the judge. So one of the factors that the jurors could have considered is that this murder was carried out with sudden passion. It's essentially a voluntary manslaughter type defense, what you see in some states where you walk in on your spouse in bed with someone else and you kill them, because you're acting in the heat of passion. That does get that murder reduced to manslaughter in most states, and in Texas reduces it from a first-degree felony, I believe, to a second degree. So I think they would have had to argue something in mitigation. To argue that he's not guilty and he shouldn't be liable at all, I think was an uphill legal battle, and ultimately it did fail.
But you think he's a murderer?
I do believe that it was murder and it was not justifiable homicide. Now, I do believe there's some factors in mitigation, his age. So I do believe that he was acting in fear. But ultimately, it's not your typical murder where you're lying in wait for financial gain and, you're a hitman where you kind of have this consideration period or period of time. So it is a murder, in my opinion. There's no legal or moral justification. There are some factors in mitigation that might have potentially got him a lesser sentence, maybe something closer to 25 years to life. Is what he would probably have gotten in most states if he had pleaded to murder. I mean, he is young, he had no criminal history. I know people in the comments are going to say that he deserves the death penalty again. Death penalty is not appropriate for a minor. The Supreme Court has made that clear. So that's probably what would have been a just result had he pleaded. But ultimately, when you push your case to trial and you don't accept responsibility, that's why he did get that 35 years.
And the medical examiner testified that the single stab wound was a large gaping wound that pierced the heart. How crucial was that specific forensic evidence in providing intent to kill rather than sort of a panicked, reckless action?
Yeah, I mean, you shank someone in the chest, right? That is something that can cause death. It did cause death, right? It's not like he slashed him and ran away. This was a very, very dangerous type of attack on anyone. I mean, you stab someone in the chest, there's a good chance that they die even with one stab wound. So I think that was a very important factor in this case to show that it was such an unreasonable escalation of force from a shove to a stab wound in the chest. I think that was really critical evidence for the prosecution.
Absolutely. And I don't think this has happened before, but we've just found out that he has now appealed his prison sentence. We were going to get to that later, but as it's just come across my desk, what do you think of the fact that he is now appealing, and where do you think he may, have any grounds there?
Yeah, there's no doubt that the defense was going to appeal. If you're going to fight this case and push it all the way to trial, you might as well just take your chances on appeal. I think the best argument they have on appeal is the Batson challenge. That was the argument the defense made, that the prosecution should not have used their peremptory strikes on the 3 black female jurors who were educators. They're going to argue that it was racially motivated. And I think that's probably the best argument they do have on appeal because otherwise, in terms of the facts, they really weren't in dispute. You have Anthony who comes into this rival tent when it's raining. There was some discussion of whether that's appropriate or not, or it's common, whether he was invited. He knew someone named Edwin. He was asked to leave anywhere from 10 to 15 times. Regardless of whether he had a legal duty to leave or not, I think that's not in dispute. You have Austin Metcalf who stood up and stood over him. There was some weight differential, anywhere from 50 to 100 pounds. He asks him to leave a number of times, then it escalates. There's some expletives used. And then you have Anthony saying, don't put your hands on me, reaches into his backpack. So if you're talking about the facts of the case, I don't think that there was a significant factual dispute here. It's just a question of whether they fit within the four corners of self-defense law. And I don't think that they did. Obviously, jurors could disagree. And I think the defense's best argument on appeal is that the prosecution systematically excluded black jurors. Now, people have referred to it as an all-white jury. I've seen that there's maybe some Asians, Latino, someone who was Muslim on that panel. But regardless, there were no black jurors, and I think that's the argument the defense is going to make.
I think there were some that were taken off because they were educators. I think that was what I read. But yeah, obviously that's going to be a big issue moving forward.
So when it comes to educators, so I don't know if this is important. The conventional wisdom is, as a prosecutor, you don't want educators on your panel, teachers, professors. They tend to be sympathetic, can be bleeding hearts, and you don't necessarily want those types of jurors who, work with kids or young adults. Again, this is a gross generalization. I love teachers. My kids are in high school right now, so I don't want anyone to come after me in the comments, but I think the prosecution is going to argue that those types of jurors, regardless of the race, are typically not the best jurors for the prosecution.
And you were talking about him not taking the stand. There were 21 witnesses, mostly students and coaches. We're talking about a 2-minute period of time for a different narrative on each side. What was the strategic risk versus reward on calling that many young eyewitnesses, to establish a timeline?
Well, those eyewitnesses saw their friend get stabbed in the chest and murdered, so that's powerful. It's rare that you see a murder committed in front of so many people. I mean, it does happen, but you have so many students, you have coaches, you have administrators. So I think it was important evidence for the prosecution. That's why they got those student, young men and women to testify about the case and what they saw. And many of them testified that it was not self-defense and it was an unreasonable escalation. But that's why I thought it was so important for Anthony to take the stand. I was shocked at the time. I thought it really, really removed any viable chance of the defense getting an acquittal because they really needed to hear from Karmelo Anthony and hear him say, and frankly, look, he's young. I know people are really upset at what he did in his family and, the fact that there was a GoFundMe raising hundreds of thousands of dollars for him. People were really up in arms, but I do think there was the possibility that he would have come across as a sympathetic and good witness and given him a chance at manslaughter. I think without it, there was no chance for the defense.
And right after his arrest, he told a police officer over the radio, "I'm not alleged, I did it." As a former prosecutor, how devastating is that, a spontaneous statement for the defense to then put him on the stand maybe and be talking about that?
Well, it's certainly bad, but in a case like this where there's so many percipient witnesses, that would have had to be conceded by the defense, really. When you're talking about murder, there's often really 4 types of defenses that you typically see. The first is, it wasn't me, I didn't do it. I don't think you could viably argue that. Second is self-defense. We've talked about it a lot. The third is, I did it, but I lacked the criminal intent. It was either an accident or, in this particular case, heat of passion, manslaughter, right? So that's a possibility. And the fourth, which comes across rarely, it's not really successful, is I did it, but I was legally insane at the time. So I think arguing that it wasn't me, I think, isn't something that would have been a good defense. So the fact that he admitted it immediately, I did think gave him some credibility and allowed him to pursue that self-defense argument.
Were you shocked by how quickly the jury came back with the verdict?
I was surprised. I thought it was a very strong case, but when they deliberate for less than 3 hours, approximately 2.5 hours, it's a testament to how strong the prosecution's case was and that a conviction was really a mere formality, not a matter of if, but when.
Obviously, this was a big success for the prosecution, but is there anything you would have done differently?
No, I do believe it's a success for the prosecution. I tip my hat to them, but really, this is a sad case. As a parent, I kind of think about it. Why did this have to happen? Why did, this fight have to escalate the way it did? And, fights happen in every high school every day in this country. And, had he not brought this knife, maybe he would have gotten punched or jumped. And I'm not saying that Metcalf was violent in any way. I was just thinking the worst case scenario as a parent. And, why did this have to happen? Really, you have two lives that were lost, two young men. Obviously, Metcalf is dead. Karmelo Anthony is going to spend decades in Texas State Prison. And it's just a very sad case, even though the state of Texas did win. There are no real winners here.
Absolutely. And obviously, in a high-profile case like this, there was a lot of noise, social media noise, political tension. How do prosecutors insulate their witnesses and keep a jury focused during something like that?
Well, what they did here is they sequestered the jury, and jurors absolutely hate that. That means their phones are taken away. They can just have an emergency number to talk to family members. It's hard enough to get men and women to show up for jury duty. And if you tell them that you have to stay in a hotel and you can't talk to your friends, loved ones, you can't, read the Sun and watch the news, that's a problem. I understand why the judge did it in this case. They even did a rare Saturday trial date where they heard testimony from witnesses because they wanted to move the case along that quickly. But it does put a lot of pressure on jurors. And at the same time, though, it protects the integrity of the proceedings because, they can't access information online and on social media.
And obviously, if we move forward with this and he does fully file an appeal, how likely do you think it is that the state will uphold a 35-year conviction?
I think it's likely this conviction will be upheld on appeal. I think the Batson, the racially charged peremptory strikes are really the best argument the defense has. But as long as the prosecution has a race-neutral reason for removing those black female jurors, and I think they do, given that they were educators, I think the Court of Appeal will likely uphold this conviction. Now, in terms of the sentence, again, it was well within the range of 5 years to life or 5 years to 99 years. 35 years does seem about right. If I had to guess, I would have guessed probably somewhere between 20 to 30 years, given his age. A little bit high, but certainly not outside the realm of possibility, given the facts and circumstances of this case.
And we have a lawyer on soon who is going to talk in defense of him. I can see you sparring there. What would you say to them in terms of, how would you defend this at this point?
I think that's really indefensible. Stabbing someone because you get pushed. Doesn't matter if you're black, white. The race of the victims were reversed. The size were reversed. Man, woman. You can't stab someone because you get pushed. That's just, in my opinion, as a prosecutor, objectively unreasonable under any circumstances. That's why there's a saying, don't bring a knife to a fist fight. That's exactly what happened, or don't bring a gun to a knife fight. This was unnecessary use of deadly force. I don't think it was reasonable for Karmelo Anthony to think that he was going to be seriously injured or killed. And I understand Texas is stand your ground. There's no duty to retreat, but he certainly could have walked away. He could have done a number of things aside from stabbing Austin Metcalf. So I believe, respectfully to my colleague that's going to argue the defense, that this is not a defensible case and this was a just result. I thought the victim impact statements were powerful at sentencing. I understand that Karmelo Anthony's mother also testified, but really his father, he had made some statements to the public, but you really saw that sadness and rage that he talked about. I think the challenge, obviously, as a parent who lost their son and, you have someone saying it's legally justified, I think that was difficult. And the fact that you have Anthony trying to walk away from this without any punishment whatsoever, I think, losing your child and then sort of being re-victimized by having to go through this proceeding, I think that Karmelo Anthony should have tried to take some sort of deal. I don't think that this was a self-defense case under the circumstances. You stab and kill someone who's unarmed. Doesn't matter who you are, civilian, law enforcement, black, white, men, women. This was wrong, and that's why I think it was so powerful.
Well, thank you so much for your thoughts on this. You're obviously still as knowledgeable as I remember. Thank you so much, and we'll see.
I'm Sam Bassett in Austin, Texas. I've been practicing criminal defense for over 38 years. I've tried probably over 100 jury trials and many other hearings and trials and criminal cases. And I've been based in Austin that entire time. And I used to be president of the Texas Criminal Defense Lawyers Association. And I still enjoy what I do and hope to do it a while longer.
And obviously, being in Texas, you must be very aware of the self-defense laws there. Is this a case that really struck you from out the gate?
Well, I generally think of Texas, with its general conservatism, except in major urban areas, as being very receptive to self-defense. In some instances, um, obviously, sometimes the home break-ins in Texas, especially rural break-ins, result in the death of the person breaking in, and very often those people are not even charged with any kind of crime at all. But the self-defense issue is a very fact-based inquiry, and I think this case had some problems.
And what do you think those problems were, and what overall is your opinion of the verdict?
I think overall the case had a problem for the defense, and that problem was the knife was introduced into the conflict very quickly, and it didn't seem, from what I know about the facts, that the conflict had risen to a high level of physical aggression yet, and then all of a sudden the victim was stabbed.
And do you feel this was in self-defense, or do you feel he was a murderer?
Well, I I think they should have considered manslaughter more seriously, but I did not think it was an intentional and knowing act of causing death. I did think that the quick reaction with the knife would lead him to be convicted, but my personal opinion was it was more likely a manslaughter case. So, but in these situations with the emotions involved and the jurors seeing the gory details and just feeling a great deal of sympathy towards somebody who has died, it's hard for a jury to come up with a lesser included charge unless you have some strong mitigating facts.
If this case came to you and he was your client, just talk us through how you would map out the defense strategy.
Well, obviously, you investigate the facts as thoroughly as possible, either yourself or with your staff or with an investigator. But you talk to the client a lot and you try to understand the situation he was in. And if there's any audio visual evidence, obviously you want to get your hands on that as soon as possible. You also want to understand what all the witnesses have told the police. Um, and then you just have a talk with your client as trial date approaches about the options of pleading guilty or not pleading guilty. And if the prosecution has made any plea bargain offers, you talk to your client about that as well. And you try to assess the risks of trial with your client based on your experience and your knowledge of the facts and your knowledge of jurors in that jurisdiction.
And obviously, there's been a lot of talk about the fact that he didn't take to the stand. Would you have put him on the stand?
It's really hard to say without knowing him. A lot of times we do not put our clients on the stand because they're just to have a difficult personality or a difficult maturity level to be able to withstand cross-examination. And we feel like they would do more harm than good to testify. In almost every self-defense case I've tried, it may be every case I put the client on the stand, but I also wasn't dealing with a teenage client. I mean, this is a young man, very young. And that's why it's sad to me that he got such a lengthy sentence. But, you have to assess the damage that can be done on cross-examination and putting your client on. You also avoid the risk. You have the risk if you put your client on of them being able to get in more information that's negative about him if he testifies on cross-examination.
And the defense wasn't very long. I think they arrested after a day. Is that something that shocks you? Would you have done things differently there?
It was a little surprising on the guilt-innocence phase, the shortness of the defense case. That doesn't always mean it's a bad defense presentation. It just means that maybe they didn't have a whole lot to work with. I sometimes have put on experts on the use of force in cases involving firearms. This was a knife, not a firearm. So it was a little more difficult case on guilt innocence than the self-defense cases I've tried.
There was also talk about the fact that cameras were not allowed in the courtroom. Do you think that was a good thing for the defense or a bad thing?
It's hard to say. It probably was a good thing. I find that judges and prosecutors and jurors, they try not to, but they act differently when there's cameras in the courtroom. And there might be more grandstanding or more of a prolonged process. So I think it probably was a good thing for the defense.
So is there anything that if you'd have taken on this case that you would have done that you think they missed out and where you think their plan failed in terms of the defense?
I was pretty curious about the sentencing phase, the lack of witnesses on either the prosecution's part or the defense's part. For those who don't understand jury sentencing in Texas, the sentencing phase involves a wide open mentality as far as what evidence is relevant to the case. You can get into bad acts by the defendant, even if he wasn't arrested for anything, any comments he had made in the past, any kind of social media posts that could incriminate him. On the other hand, the defense can get in expert testimony regarding the defendant's psychological makeup. You can often put on, in this case, coaches, teachers, and other people who could vouch for his character, to get the jury thinking about the human side of the defendant and to get them thinking about whether or not they should send him to prison for a long time. I was surprised that there was not that type of evidence. However, one thing to know is if you put on that type of evidence at sentencing, it often opens the door to otherwise inadmissible evidence that the prosecution could put on. And I'm very curious. There was a long meeting, I think on the Monday of trial, behind the scenes with the judge and the lawyers. And I'm wondering if there was some sort of agreements made between the prosecution and the defense about limiting certain evidence as the trial was reaching an end.
As we spoke to your colleague, he feels he is a murderer. You know, he deserves this sentence, 35 years behind bars. As we're talking about the human side of it, how do you feel about, he's 19 still. What are your thoughts on him now spending many, many years in prison?
Well, my thoughts are that oftentimes the sentencing of a jury in Texas is kind of a thermometer of anger. And I don't really like looking at it that way, especially with young defendants, especially since we have all this research that talks about the brain development of a young man really is not finished until they're in their mid-20s. And I really think this young man was just months from being a legal adult in Texas. 17 is considered the legal adult age in Texas, and that's when he committed this offense. And recently the legislature almost passed a statute saying that the legal adult age should be 18. So there is recognition that we don't take young people in the same way for sentencing as we do older or even younger adults in their 20s. So to me, that's the unfortunate part of the sentencing, is that this young man, barely able to drive a car legally, is given the same sentence and judged on the same template as somebody who's in their late 20s or 30s. I just think the sentence was too harsh.
So you feel that the sentence was too harsh. Can you tell us exactly what you think the sentence should have been, if any, or do you think he should have walked free?
Oh, these are all my personal opinions, but I do think he probably should have been convicted of some homicide, because of the introduction of the knife so quickly. But I always felt like it was a 15 or 20-year case, in my mind. But then again, I'm a biased audience on that. Again, he was just barely a legal adult when this happened. And for the life of me, I can understand emotionally how a Collin County jury would give the 35-year sentence. But and I know the sympathy for the deceased and the young man and his family has to feel terrible and angry about what happened. But I just still think the sentence was too harsh.
And there was significant public controversy regarding the jury selection, specifically that no black jurors were seated in the final panel. How do you think that played into it? And do you think that that was unfair?
I don't know that it would be considered legally improper. That will be decided on appeal. I understand there were 3 African American jurors who were struck by the prosecution because they were teachers or had experience in the teaching field. Um, and that came up because the defense challenged those strikes under a Supreme Court case called Batson. And under such a challenge, you have to give a race neutral reason as to why you struck certain jurors. So it may hold up on appeal, but in my opinion, subconsciously at least, the race always matters. It is naive to think that a all white and Asian jury has the same attachment and concern for a defendant who is black than they would for a defendant who is Caucasian or Asian, in my opinion. My experience is the cross-racial bias still exists in the system, even if you're complying with the law. So it's a big concern, especially when it came to the severity of the sentence of mine, that race did play at least a subconscious factor. Now, nobody's ever going to admit that that was a factor in their mind as a juror, but I think it is a subconscious factor that we are always concerned about when we're trying cases as to the racial composition of the jury.
And obviously, we've said now that he is appealing. He is filed to appeal today, in fact. Is this an uphill battle, do you think, for the criminal defense lawyers involved in this? And how would you tackle it yourself?
Well, I'm not an appellate lawyer. I've handled some appeals, but the trial result usually stands in 95% of cases in Texas. And the best he can probably hope for is a new trial, not an acquittal. Or there's some circumstances on appeal where you can be rendered not guilty, but that's very rare. But any success on appeals in Texas is very rare, and it's really 5% or less of criminal cases result in a new trial on appeal.
So this is an uphill battle. What would you introduce to try and get a new trial? Do you think there's anything there that's glaringly obvious that they could use?
There's nothing that's obvious to me. I think that's why appellate lawyers examine the record carefully and study the judge's rulings and the objections made to determine if there's an appeal ground. For those of you watching, an appeal is just a review of the legal rulings in the case. And that includes the jury instructions. It includes rulings on objections throughout the trial. It includes what we were talking about a second ago regarding jury selection. But it does not include just a review of the whole trial as to whether or not the appellate court agrees with the verdict. So it's a very limited ground to get a new trial.
And obviously we saw immediate clashes and arrests outside the courthouse right after the verdict was read. Were you shocked by that?
Obviously, after the trial, the emotions that everybody held going into the trial all kind of came out. The judge did as good a job as he could, I think, of limiting the access by having a gag order and also having a perimeter that people had to stay outside of around the courthouse. It is difficult as a judge to deal with jurors feeling pressure or outside influences in a trial like this. So the emotions that came out afterwards are not surprising.
And for those who obviously work in criminal defense, what do you think, for those who've followed this case, do you think they will remember from this? And is there anything they'll take forward into similar cases?
I think the comments of other defense attorneys I've talked to somewhat echo mine. Is the sentencing presentation was very, very brief, and as a criminal defense lawyer, you have to prepare for sentencing, even though you want to win the trial. You have to be prepared for the sentencing phase, and you have to put on, unless there's other reasons not to, you have to put on a uh, robust sentencing evidence, because sometimes some of the jurors will understand what you're presenting. Other jurors may disagree, but you're always trying to strengthen the people who want the lesser sentence and give them a reason to persuade the others who want a long sentence to lower their vote.
In what ways do you feel they were unprepared?
I don't know that they were unprepared. They seem to have made a decision to put on a very quick sentencing phase. And I don't want to criticize them without knowing everything they were dealing with. It's possible they had a very rational and good reason to not put on a lot of character witnesses. Perhaps there's some evidence out there that would have come into the jury if they had done that, that would have been devastating to their defense and their sentencing argument. So I think that they seem to have, these are experienced lawyers and they're respected lawyers. So I never second guess lawyers unless and until I read the whole record and can't and talk to the lawyers as to why they put on a brief sentencing phase case.
And finally, we were talking to Nima, and he said there are no real winners here. To sum up, how do you feel both sides are feeling now after this verdict?
You know, a lot of people who have lost a loved one in a crime sometimes, I think, are misguided, that they think a trial result or a guilty verdict will give them closure. I don't think that that's usually true. I do think they have a valid uh, point in that they want to see justice done for their loved one. They don't want somebody who killed their loved one to just walk free or get a very short sentence. However, I think that they they sometimes are misguided that a long sentence is going to make them feel good, and it nothing makes you feel good when you've lost a loved one to a random criminal act like this. On the other hand, the family of the defendant is just devastated. I've dealt with a lot of families who have a son who's sentenced to a long prison sentence, and it's just devastating. It is sad. You're angry. You oftentimes will second guess the lawyer's work because you don't want your loved one to go to prison. But those are all natural emotions that family will be going through as well.
Definitely. Well, I think we're going to be hearing a lot more about this as the weeks go on, and it'll be interesting to see what they actually outline in the appeal. Thank you so much for joining us, and I'm sure we'll be speaking to you again about this one.
Thank you.
Well, those were two very different opinions. One side agreeing with the jury that Karmelo Anthony is a cold-blooded killer who should never have had a knife on him, let alone fatally stab another student. And a criminal defense attorney who feels 35 years behind bars was excessive, and that maybe his legal team should have spent more time focusing on the sentencing phase, as he has his whole life ahead of him. Do you think Anthony's appeal will be a success? Let us know in the comments, and please like and subscribe for more.